The set of forms that we will be discussing in this packet is for those parties that have property to divide but no minor children, and this is packet number 3. And you should have all the forms that I will be going over with you right now. There is 2 forms that are highlighted for you to fill out, and the next 2 forms are to take with you for the final hearing. And we will go over each of the form as I begin. And as you can see, it says petition for dissolution of marriage, marital settlement agreement, and final judgment of dissolution of marriage. And I will go over each of the form now. And if you go over the first page, which is a title page, there will be 4 pages of instructions regarding the dissolution of marriage. And I will not be going over the instructions. Instead, I will go over the actual form for you. As we pass through this, the next form should be right there. So the petition. This is the important form, and I'm not going over the instructions only because I am summarizing for you the instructions that are involved, so you would not need to go over it through this video. However, those instructions are there for you to consider if you have any questions and you needed a little bit more clarification after this video and when you're filling out the form. So those are for you to use if you need them. However, prior to submitting all the paperwork, you can disregard or discard those instructions. So what's the first form? The first form is the petition for dissolution of marriage with property but no dependent or minor children. And what that is, with property means assets and liabilities that you need to divide. But no dependent or minor children means there are no children here, so you do not have to discuss the issue of custody and visitation. If you have property and minor children, you're going to have to use packet 2. But if you have no property and no children, you may want to use packet 4 because it's a little bit shorter. But it's ultimately up to you which form you use. However, it's a little bit clearer for the court if you file the correct form. So I will recommend, if you have property and no children, use this form. If you don't have property and no children, use packet 4. And if you have property and children, you want to use packet 2. So just to let you know, clarify that section. Okay, so when we begin the form, you're going to have to fill out the top as you did all the other forms that you're going to be filing with the court. And this is just to identify where the case is going to be filed. And so you're going to include that information, and I will go over each of the sections outlined and each of the numbers that you have to fill out and make sure it's completed for you before you file it with the court. All right, since you, the petitioner, are the one seeking the divorce, you have to write your full legal name here before you fill out the remainder of the document. So you're just saying, I am the petitioner, and I'm filing this petition, and everything I'm saying is true. And then you'll have an oath at the end before you get it notarized. So number 1 talks about jurisdiction and residence. And what jurisdiction is whether the court has the power over you and the action to grant you what you want. And I briefly discussed it when we were going over packet 1. And the reason why it's required is if the court doesn't have jurisdiction, then the court, whatever the court orders or anything that it enters, has no legal effect. So the court wants to make sure you have jurisdiction and that you're a resident of the state of Florida for at least 6 months before you file this action. And here in the state of Florida, you both could be a resident, or just you or the petitioner has to be a resident for at least 6 months. So you would check whichever one applies to your situation and make sure at least one of you has to have been a resident of the state of Florida for at least 6 months. Okay? And number 2 is about military service, and you have to check whichever one applies, whether either of you are in the military or not in the military. So you're just letting the court know. It's just a summary of the affidavit of military service that you did. And number 3 is the marriage history. This is just a summary of your marriage. You have to include the date of marriage, date of separation, and place of marriage. Oftentimes, people might not have date of separation. So if you don't have that, you don't have to write that. Meaning, if you never separated, you're maybe still living in the same home, then this may not apply, and you could leave it blank. And it's not that is as important as the date of marriage and place of marriage. And if you don't know the exact date, you could always write the month and year. However, it's good to have the month, day, and year. And I mentioned date of separation. It may or may not be important to your case. Sometimes it's important, especially if you're discussing division of property and you've been separated for a long time. Although the state of Florida does not recognize what most states recognize called legal separation, where it's actually you're separated and the court say, although you're not divorced, you're not married, you're not really married, and they may use it as a basis to determine whether there is marital property and non-marital property. And this is important in your, it may be important in your instance, especially if you're debating whether any new debts that the other party may have accrued while you were separated. You could legitimately argue that it's not a marital debt because he or she accrued it while they were living on their own separated from you. So that may be important or it may not be. So I just wanted to let you know about that before you fill out your form. All right. And number 4, you're saying there are no minor children common to both parties. And what that means is that there are no minor children that you as the petitioner and the respondent have had. This form may still apply to you if you have children under the age of 18, but they are not common to. So if you have a child from a different marriage, you can still use this as long as the child is not common to the person that you're seeking the divorce from. Okay. And number 5 is the notice of Social Security number, which we filled out in packet 1 and will be included once you complete all the packets. And 6, this is the most important part of the actual form that you're filling out. And this is saying this petition for dissolution of marriage should be granted because 1, the marriage is irretrievably broken, or 2, one of the party is determined to be incapacitated. And I would say 99.9% of the time is 1, the first one. The marriage is irretrievably broken. And as I briefly mentioned, Florida is a no-fault state, meaning it doesn't matter why you want to get a divorce as long as you want to get the divorce, and the judge should usually grant it. In some states, you have to have a legal basis for divorce, but in the state of Florida, you don't. It's basically, I don't want to be married anymore, so I want a divorce. And the second one involves someone that's been determined to be mentally incapacitated for at least 3 years, and there has to be a judgment. What that means that there was a court of law or a judge that determined that person is incapacitated. You can't just say that my husband doesn't know what he's doing, so I want a divorce. You have to have had the court say your husband is incapacitated, they can't make any legal decisions, etc., etc. So you have to make sure that you're going to be able to meet this standard if you're going to be using the second one. But I highly doubt you can use it, so I would always check the first one. Okay, so after you finish the first section, we're going to go over the second section. This section involves, as the title suggests, marital assets and liabilities. When we were completing the financial affidavit, we had to list what we considered marital asset, non-marital asset, marital liabilities, or non-marital liabilities. And because you've indicated by using this form that there were some assets and liabilities or property to divide, this is where you're going to determine or request how it should be divided. And so number 1 says there are no assets or liabilities to divide, meaning I'm keeping mine, he or she is keeping his or hers, and there's nothing to divide. Again, if there's nothing to divide, I would recommend you use packet number 4, but you could still use this as there's no issues regarding that, because then you might have some issue regarding spousal support. So you could say there's no assets, but I want alimony. So this may apply to you if that's your situation, because in packet 4, you're giving up your right to alimony. Okay, so let's go on from there. So if you have no assets and liabilities, you would check 1. In some instances, you might check 1 if there are assets and liabilities to divide, but you're both saying it's not worth it. We're not fighting over what we're going to divide, so it's okay. What we're really going to argue about may be alimony. So then you could still check 1. So if there are assets and liabilities you want to divide, there's two ways that you could divide it. The first is you could reach what we call a written agreement, marital settlement agreement, which we included in the packet, which is the next form that we're going to go over. This is basically telling the court that you and the respondent have reached an agreement on all the issues, or how the assets and liabilities are going to be divided. And when I go over the form, you can see how it's done. But you have to make sure, if you choose to enter into agreement, that you both sign the agreement. So if only one of you signs it, that is not agreement. You both have to sign it. And the second way that it could be divided is through the court. And when it is done through the court, it's usually after a final hearing. A final hearing is basically a trial where you go in front of the judge or the magistrate, you present your evidence about who should get what, and the court decides who should get what. So that is what B is, the court should determine, because you couldn't reach an agreement as you would in A. And C is specifically for you, the petitioner. If you're a petitioner, you could say, I am entitled to X, Y, and Z because X, Y, and Z. I contributed to the home. I paid half of the house. I paid half of the vehicle. I paid half of the boat. I paid, I made money while he was not working and I paid for it. So you just want to let the court know why you should be entitled to that property, the other spouse's property. So you could say it's not his property, it's marital property, so it should be divided such and such way. So this is where you would explain to the court how it should be divided. And if you reached an agreement to A, C would not apply to you. C would apply if you were seeking the court to make that determination. Okay? And the next section is spousal support. As I mentioned earlier, you may not have any property to divide, but you may have some type of income that requires you to seek spousal support or alimony. And similar to giving up assets and liabilities, you could also give up your right to spousal support. And this right, once you give it up, you can never get it back. So if you give it up now and the court enters an order, says you gave up your alimony, you can't come back a year from now, 2 years from now and say, you know what, I changed my mind. He has all this money. He could afford it, so I'm going to ask for it. So you have to be aware that this, if you give it up now, you're forever waiving that right. So, or you could say number 2, I am requesting the court to grant me alimony. And how does that work? So to be entitled to alimony, there's 3 things that you have to consider, or the court has to consider. One is whether the person seeking the alimony has what we call a need, meaning they need that money to survive. 2 is that the person you're requesting the alimony from has what we call the ability to pay, meaning they are able to pay you because they have extra income. And 3, the court has to consider how long the marriage was. If it's a short-term marriage, it's considered 1 to 7 years. So if you've been married from 1 to 7 years, the court may determine a short-term marriage, and you may, I say may because you may not be entitled to alimony. 7 to 17 years, you're considered a midterm, moderate, they call it midterm or moderate marriage, and you may, more likely than not, get alimony. Again, you have to meet the requirements that you have to have a need and the other person has the ability to pay. And finally, 17 years and above is considered a long-term marriage, so you will most likely get it, but you have to, again, find that you have the need, meaning you need that money, and the other person can afford to pay you. So you have to meet those requirements before the court can award alimony. And then there are different types of alimonies that you could seek. You could seek temporary, permanent, bridge the gap, durational, rehabilitative, or lump sum. Temporary is for a certain period. Usually it's for when you're going through the divorce and you could say, I just need a certain amount of money while we're going through the divorce, because sometimes the divorce can take years. So if you need money to survive, you could ask for temporary. Permanent is just as it sounds. It's for those when you need the money for the rest of your life. And that's usually if you've been in a long-term marriage. I've very rarely seen the court grant permanent alimony for a short term or a midterm. It's usually for long-term marriage people that's been married over 20, 25 years. And bridge the gap is for a short period of time where you're meeting from one period to the next that you need that money. Usually I need it so that I could get accustomed to my lifestyle without your income. So I need it while I'm getting to that point. That's similar to durational. So it's usually for a certain period of time, usually 2 to 3 years, maybe 5 years, and sometimes it could be even 7 to 10 years, saying I just need it for this period of time to get back on the feet, or I need to go to school, I need to do X, Y, and Z. So that's what durational is. Rehabilitative is what you would seek if you need the money to basically get back on your feet. And it's also for when you going to school, trade, you need to get certain skills, and you need it to get to a point where you could get steady income where you don't need the alimony any longer. So that's what rehabilitative is. And then lump sum is as it sounds. It is lump sum, set amount, you get it once and you're done. And oftentimes people would use lump sum as a form of negotiation so that the other party, I don't want to get paid $100 a month for the rest of my life. I'd rather get $20 right now, and then I won't ask for it anymore. So that's how lump sum works. So you have to decide what type of alimony you need and what type of alimony you think he or she is able to pay you if you need it. So you have to consider that when you fill out this section if you're going to seek it. And 3 talks about any tax liability. So in some states, in most places, they consider alimony income. So how is that going to impact you if you're working and receiving alimony in terms of tax consequences? So if you think you're going to have impact like that, I would highly suggest you talk to a CPA or tax attorney so that you understand the pros and cons of receiving alimony. And it also impacts the person that's paying. So you have to take that into consideration. So you include that. And then number 4 is talking about the life insurance. So if you're receiving, or if the court orders alimony, you can ask the other person that is paying the alimony to obtain some type of life insurance so that if they pass away, that there's some money coming to you. Because if they pass away and you're receiving alimony, you will no longer be receiving that money. So in some instances, the court will allow the other party to get insurance so that if you, for some reason, if they pass away, you should be listed as a beneficiary to that amount. But you have to consider they're not going to be telling that a person to get $1 million life insurance if you're only receiving $100 a month. So yeah, it's something to request from the court, and it will be for a reasonable amount. All right. So we went through assets and liabilities and the alimony. So the last section, second to last actually, is other. Other involves issues that were not discussed above. That's all it is. So one of the issues that you can consider is if you're a woman that married and changed your name when you got married. So you married your husband and changed it to his name. And now once you get a divorce, you could ask the court to change your name to go back to the name you had prior to your marriage, so your maiden name. And the reason why they allow this is because once you're divorced, you're no longer married, you could go back to your maiden name. However, it takes a court order for you to change your name. While it was easy to change your name when you got married, when you get a divorce, you need a court order. And so in Florida, they allow you to do it through the divorce action. The reason why they ask you if you want to do it now, I recommend you get it now, is because if you say no and then decide later, 2-3 years from now, I should have gone back to my maiden name, you'd have to file a separate action, and that will cost you money. It's a separate court action. You have to go through the court to get a court order to change your name, and it's at least $400 filing fee. So, and if you hire an attorney, that's maybe another $1,000, $1,500, depending on the attorney. So that's going to cost you almost $2,000 to file. So if you think you may want to change your name, I would recommend you do it now and hold on to that court order, because you don't have to use it to change it, because you have to take that next step once you get the court order to go to the courthouse, not to the courthouse, to DMV, to Social Security, all those agencies' passport, to have your name changed. Then they will do it for you. However, if you just hold on to it, you don't have to do it right away. So it's up to you what you want to do. If you don't care, then you don't have to change your name at all, and you don't have to worry about it. So what are other relief? Other relief is anything else that wasn't discussed above. Usually assets and liabilities are included in that, but sometimes there are things that are not really included in the assets and liability. One of the things I usually bring up is pets. If you have pets that you both love and you don't know who should get quote unquote custody, then this is one section. Unfortunately, in the state of Florida, pets are not divisible through custody orders. They're considered property. So, but they're not considered assets or liabilities. So this is one section you could request how you're going to do the pets. If we've had cases where people had custody and visitation for pets. So it's something to consider. And section 4 is the final section. It's request. So this is just a summary of everything you've requested. First is the petition you asked for the divorce. Then if you had distribution of assets, spousal support, restoring name, anything else. So you would check anything that applies. If it doesn't apply, don't check it. And once you finish all of that, you're going to have to get this form notarized. And it's important that you get it notarized, otherwise the clerk will not accept it. So you finish that form, and the next form we have is the marital settlement agreement. And before I go over the form, there's 2 pages of instruction. Before I go over the form, this is a voluntary form, meaning it's not required. You will only use it if you and your spouse could reach an agreement. Because, as you see here, it's a marital settlement agreement, meaning you both agree. And you both have to fill it out together. So you say, we, petitioner and the respondent, are agreeing to X, Y, and Z. So if you think you could both agree, you will fill this form out and both sign it. However, if the other party is not going to sign it, you don't have to fill it out. You could just disregard this form. But if you choose to fill it out, you have to make sure the top is filled out and you both named, and you have to list everything. You're going to saying why you want the divorce and how the assets are going to be divided. So it says the petitioner shall receive, and you're going to list everything that the petitioner you are going to get. See everything and how much you're going to get. And then the next section is where the respondent, everything that he's going to get or she's going to get. So you're going to have to list all of that if you look at it. And then the next section deals with any type of liability. Who's going to pay what? What are the outgoing, what are the liabilities that you're going to divide? It talks about loans. So then you're going to write what is the respondent going to pay? And then everything, you have to list everything. And all the issues that were discussed in the petition, this is agreement that you're going to reach. And then it talks about the spousal support. Are you giving it up, or who's going to pay what? So you're going to have to list all that there. And again, this is you and he or you and she working together to fill the forms out. You can't just fill it out on your own and not submit it and try and get it expected. So as you see in the last page, you sign it, and then the next page, he or she signs it. And what you have to do is you have to both sign it and file it together with the other party or with the forms. So you both have agreed and filled out all the forms together. What will happen next? Most likely you will not have to have a hearing, and the court should accept everything. And if they do accept it, this is the final judgment the court is going to grant you. And this section, you only have to fill out the top, because this is the form the court is going to sign. Final judgment of dissolution of marriage. This is what we call, quote unquote, the divorce decree. So this is the form the court will be sending back to you to grant you the divorce. So uncontested means you both agreed, so the other party is not contesting the divorce. The court will probably accept the agreement, and you see it says marital settlement has been agreed, and then the court will sign it and send it back to you. Generally, if it's uncontested, you could go to the hearing and only one of you have to show up and it should be accepted. Oftentimes, what parties try and do is you could both go together and say, yes, we both agree to the agreement. And that makes it a little easier. So once you get that, the court will sign it and send you both a copy. So what if you don't agree and you can't reach an agreement? The second form is the one that you're going to have, the court will fill out. Again, it's the final judgment, and it doesn't say uncontested, which means the court has to hear evidence and will make a determination. So this section has to be filled out, and that's the only section you're going to fill out and bring it to your hearing, because the court will make a determination about everything after the hearing. Basically, the court will listen to your evidence, witnesses, any documentary evidence about why you should get what, he should get his, she should get hers. Then the court will make a determination. And again, the court is going to make a determination about all the assets that are out there and who's going to get what. Petitioner shall get, respondent shall get. And this is what the court will fill out. So you don't have to fill out any of it. If you reach the agreement, you both have to fill it out, but not here. So here, liabilities, the petitioner shall pay, respondent shall pay, and he or she will go over each of the assets and liabilities, and whether there's going to be any beneficiaries and who gets the home. Especially if there's home, then the court can decide whether you're going to sell the home or keep it together. And then alimony, what type of alimony that you're going to get and who pays what and for how long. So the court will make all this determination, fill it out by the court, and then send it back to you. Sometimes the court may fill out or complete its own form. So if that happens, then you will receive a copy of their form or their order that the court fills out. And he will do all that. How are you going to pay alimony? Who's going to pay alimony? Are you going to do it through person to person or through a different agency, and all that fun stuff? And if there's an attorney, then there might do attorney's fees. If you don't, then it doesn't apply to you. And just like the other form, it says the circuit court done and ordered, and this is what the form will fill out. The judge will fill out. So once you've completed this packet, which is basically the first form, you're going to compile it all, and the next section we're going to go over is process of service.